The structure of the state courts in Texas is essentially a three-tiered system. Trial courts, such as county courts at law and district courts, sit in each county of the state, and they hear both criminal and civil cases. Civil cases involve disputes about money and property and business interests, things of that nature, and also family law cases, probate cases, things of that sort. Criminal cases involve a claim by the state through indictment or information that an individual has violated a criminal statute and is subject to imprisonment or a fine. The next tier of cases are the courts of appeals. These are intermediate courts of appeals that hear both civil and criminal appeals from the county courts at law and the district courts across the state. These courts of appeal are all regionally based and are seated in a specific city and hear appeals from the surrounding county. The third tier of courts is the Texas Supreme Court and the Texas Court of Criminal Appeals. The Supreme Court hears appeals from the intermediate courts of appeals in civil matters, but does not hear criminal appeals. The Court of Criminal Appeals hears the appeals from intermediate courts of appeal on criminal cases. There are currently 14 intermediate courts of appeals. Each of them is seated in a specific city and has regional jurisdiction of cases coming from the surrounding counties. Houston has 2 courts of appeals. The first court, which was moved from Galveston to Houston in 1957, and the 14th Court of Appeals. Fort Worth has the 2nd Court of Appeals. Austin, the 3rd. San Antonio is 4th. Dallas is the 5th Court of Appeals. Texarkana is the 6th Court. Amarillo is the 7th Court. El Paso is 8th. Beaumont is 9th. Waco is 10th. Eastland is 11th. Tyler is 12th. Corpus Christi is 13th. And again, Houston has 2, including the 14th Court of Appeals. These 14 courts of appeals have jurisdiction over both civil and criminal appeals from trial courts in their geographic jurisdiction. Senate Bill 1045 creates a new 15th Court of Appeals that is similar to the 14 courts only in that it hears appeals from district courts and differs from the other 14 Court of Appeals in that it is not regionally based. It is a statewide appellate court, and it has only civil appeal jurisdiction over specific jurisdictional matters. It hears appeals from cases against the state of Texas, state agencies, and state officials in their official capacity. However, it also includes cases against state universities and their employees and officers. All of these claims against state officials will exclude family law or personal injury or employment discrimination cases, things of that nature. Many of the cases against the state and state agencies are currently tried in Travis County District Courts and are appealed to the 3rd Court of Appeals in Austin. So this new 15th Court of Appeals will involve a transfer of a substantial number of cases from the 3rd Court to the 15th Court of Appeals. The second area of 15th Court of Appeal jurisdiction is cases challenging the constitutionality of state statutes or state rules. If the Attorney General is a party, the Attorney General has authority to intervene in lawsuits seeking a declaration that a statute or rule is unconstitutional, and therefore these cases will be appealed to the 15th Court of Appeals. Then the third area of jurisdiction for the 15th Court of Appeals will be appeals from the newly created statewide Business District Court. To hear more about that court, you can see the video from my colleague Paul Skeith. Essentially, the trial court jurisdiction for the business court will involve business disputes in which the matter involves a controversy of $5 million or more. And those cases will be appealed to the 15th Court of Appeals. One important aspect of the 15th Court of Appeals is that it is not subject to docket balancing transfers. The Texas Supreme Court has set up a system to transfer cases from crowded appellate dockets to other courts that have less crowded dockets. This transfer system will not apply to the 15th Court of Appeals. So all cases that are subject to the jurisdiction of the 15th Court of Appeals will only be decided by the newly created 15th Court of Appeals. Senate Bill 1045 also provides that the court will only come into existence when there is a legislative appropriation specific to the 15th Court of Appeals. A contingent provision of the current budget provides an appropriation for the 15th Court. Therefore, it is expected to begin operations in September of 2024. Initially, from 2024 to 2027, there will only be 3 justices on the court. That will expand to 5 justices in 2027. The initial justices will be appointed by the governor.